Yes.
Thank you very much, Your Honor. As we come to the close of our debate on Bill C-7, I wish to acknowledge that the Parliament of Canada is situated on the unsurrendered territory of Indigenous peoples. And I am not going to move an amendment to Bill C-7 today. But I do wish to take this final opportunity to place on the public record some concerns and observations for future reference as this deeply flawed bill morphs from a draft that has worried and galvanized every single national disability rights organization in this country and been the catalyst for the rare occurrence of 3 independent UN experts issuing a joint report on the discriminatory nature of this hasty, ill-considered bill. I want to express appreciation for the quality of our deliberations on this bill and to all honorable colleagues who have presented thoughtful and concerned speeches and amendments adopted here in the hope that they will be incorporated before this bill becomes law. And I wish to extend kudos to Senator Petitclerc for her deft sponsorship of this bill. I speak today still convinced that Bill C-7 really should not be before us today, but it is, because the government consciously chose to ignore the expertise of disability rights leaders representing hundreds and thousands of people living with disabilities and refused to appeal one lower court decision and refused to conduct the legally mandated review of the current law before rushing ahead with this bill. The coalition includes British Columbia Aboriginal Network on Disability Society, Council of Canadians with Disabilities, Canadian Association for Community Living, the Disabled Women's Network of Canada, Inclusion Winnipeg, Community Care Manitoba, the Arch Disability Law Centre, where I actually began my career as a lawyer, and People First of Canada. The UN and Canadian disability rights experts have spoken to us in one voice, clearly alerting Canada that this bill is highly likely to produce dangerous and discriminatory situations that will happen to people living with disabilities, far from the notice of this chamber, far from our being able to do anything about their dire situations, unless we decide collectively that senators are not going to look away silently once this bill becomes law. You will recall that the Disability Rights Coalition has now grown to over 90 organizations, and some of us have already given voice in this chamber to the carefully considered objections conveyed by the coalition and by experts from Indigenous communities, so ably conveyed by Senators Anderson, Boyer, and McCollum in particular. Today, I want to look briefly but more closely at the ignored advice from the 3 independent UN experts: the Special Rapporteur on the Rights of Persons with Disabilities, the independent expert on the enjoyment of all human rights by older persons, and the Special Rapporteur on Extreme Poverty and Human Rights, all identifying the human rights violations likely to occur when Bill C-7's expanded access that singles out people with disabilities who are not dying becomes the law of this land. Yes, disability rights organizations will have lost this round when Bill C-7 becomes law. But this is not the last time that senators will be tasked with addressing the discriminatory after effects of Bill C-7. We are charged to uphold the rule of law in Canada, including the rights protected in the Universal Declaration of Human Rights, in the UN Convention on the Rights of Persons with Disabilities, and in the International Covenant on Civil and Political Rights, all accepted by Canada as essential treaties in our adherence to international human rights law. The UN experts conveyed that the bill, quote, appears irremediably entangled in ableist assumptions about people with disabilities, end of quote. They elaborated that, quote, the eligibility criteria set out in Bill C-7 may be of a discriminatory nature or have a discriminatory impact, as by singling out the suffering associated with disability as being of a different quality and kind than any other suffering. They potentially subject persons with disabilities to discrimination on account of such disability. Please allow me once again to have the honor of conveying in this chamber the collective voice of the Disability Rights Coalition, representing hundreds of thousands of people living with disabilities, and the voices of Canadians caring for those they love who are living with disability and for whom they are desperately worried. Colleagues, I was honored to serve as a Chief Commissioner for Human Rights in Saskatchewan. And last evening, I received a note from Ontario's former Chief Commissioner, Catherine Frazee, whom I have known, worked with, and greatly admired for many years. Professor Frazee wrote about the significance in law of the Convention on the Rights of Persons with Disabilities, the CRPD, reminding that the CRPD, quote, is not an abstract set of aspirational principles. It is a multilateral treaty to which this country knowingly committed itself, end of quote. While respecting the right of each senator to decide, Professor Frazee wrote last evening, from her perspective as an esteemed disability rights defender who has lived her entire life with a disability, of the impact of senators voting for this bill. And she said, your vote will weigh heavily against us as we endeavor in future litigation to claim its authority in Canadian and international law. I plead with you, do not permit your vote on the record to become weaponized against Canada's disability rights movement. Known that others will make use of your decision in ways that you do not actively intend. If you absolutely cannot and will not vote to defeat Bill C-7, then please, please abstain from the vote. End of quote. In closing, dear colleagues, please consider this young leader's analysis. She said, Bill C-7 is anti-working class, racist, and ableist. These are the words of Sarah Jama of the Disability Justice Network of Ontario as she spoke at a virtual news conference last week while we were debating this bill. She went on to say, the bill makes it more accessible for people with mental health disabilities to kill themselves as a form of treatment without making mental health supports free. As we work our way through the challenge of recovering from this pandemic, we need to understand so much better the connection between poverty and the denial of rights. We need to continue, as so many of us have done already, to raise our voices as strongly and collectively as we possibly can around issues like guaranteed livable income and anti-racism education and the gathering of data and disaggregation of that data on the basis of racialization and social exclusion. Ms. Jama is a 26-year-old community organizer from Hamilton, Ontario, who is Black and uses a wheelchair, and she was called as a witness before the Senate Legal Committee, so graciously and skillfully chaired by Senator Mobina Jaffer. Ms. Jama reminded senators that Joyce Echaquan, a 37-year-old Indigenous woman, died in a Joliet, Quebec hospital last September after she filmed staff making cruel and racist comments about her. And Senator Pate reminded us by comparing Ms. Echaquan's suffering to the compassionate end-of-life care provided in the same hospital on the same day of a much more privileged white man. Ms. Jama said, "I don't want this in my future." Nobody in this chamber wants such exclusion and killing discrimination in Ms. Jama's future. But it is with a wrenching sense of irony that I close by observing that Bill C-7 as law will contradict the promise that Canada has already made in the CRPD. Quote, "States parties reaffirm that every human being has the inherent right to life and shall take all necessary measures to ensure its effective enjoyment by persons with disabilities on an equal basis with others." End of quote. Colleagues, this bill dresses up discrimination and calls it a right, but that does not make it so. This bill is discrimination on the ground of disability, writ large. Merci, miigwech.